Public Affairs very much thanks Residco, our sole corporate underwriter, for helping to make the production of this show possible.
The Dobbs Court went through an analysis of the law at the time the 14th Amendment was ratified, which is in 1868, and almost every state that was in existence at the time banned abortion, and the territories that later became states banned abortion. So they said this is not a right that's firmly rooted in the history and tradition of the United States. In fact, the opposite is true. There was no right because abortion was illegal throughout the land in most states and in almost every circumstance.
Welcome to Public Affairs. Folks, we're right in the middle of what I call the quadrilogy. We're doing 4 shows on the Illinois Supreme Court race. We have two contests, the Illinois Supreme Court 2nd District, Illinois Supreme Court 3rd District. This is important stuff. We're in an election season in a gubernatorial race, attorney general race, and so forth. Sometimes, and zillions of judges are being voted on. Not zillions, that'd be sort of an exaggeration, but many. And right at the peak of that is the Illinois Supreme Court, the highest in Illinois of the judicial system. So this is important stuff. And our guest today is Justice Michael Burke. He is currently sitting on the Illinois Supreme Court in his second district. He's running in the 3rd district. More about that as we get into the details of the show. But that's kind of it. And we can ask, but we probably wouldn't get an answer as to how he would rule on an issue that might be likely to come before him. But the issues of abortion and guns and crime and pensions, 4 shows. We've done 2 shows with Mark Curran. We've contemplated doing 2 shows with Justice Michael Burke. We have these concepts that I say are key, that seem to be key, that the Illinois Supreme Court may be dealing with, that we're thinking about. They also are concepts that the U.S. Supreme Court has on its mind. They also are concepts or topics that America's thinking about. Abortion, guns, crime, pensions. So to give people an idea about who you are 40 years or so in the law.
Correct.
And you then became a prosecutor, assistant state's attorney, DuPage, right?
Right.
You've been in DuPage for the last 40 years or so, right?
Correct.
You're a DuPage guy.
I am. Well, I was born and raised on the south side, but when my wife and I were married, we moved to R-Elmhurst, and we've been there ever since.
And you were a prosecutor for 9 years.
Right.
And was it chief of the Special Prosecutions Unit?
Right. My last assignment there was chief of Special Prosecutions.
Also were a felony trial supervisor?
Also, right before that, yes.
And trials are important. Trials, if you want to be, I would think, if you want to be on the Illinois Supreme Court, it's important you know about trials, right?
Yes. I mean, a large part of what we do is to review what happened below, what happened in the trial court, to determine whether or not error was committed. And having tried cases and presided over cases is certainly beneficial.
So, and you were a trial supervisor, a felony trial supervisor at the state's attorney's office, but you were a participant. You knew how to do trials.
Right.
You weren't just supervising.
No.
You were doing it, okay?
Right.
You were what? Was it prosecutor of the year one of those years when you were there?
I was, 1988, which was a while ago.
While back. And while you were there, you did 65 felony jury trials, right?
Right.
People know, they've heard felony, that's the bigger case, more sophisticated, more complicated. Misdemeanors, a little less so. But you did 65 felony jury trials. You did 30 misdemeanor jury trials. You did 100 bench trials. You know trials.
Right.
You know so when you're reviewing this, if you do get, well, you're on the Supreme Court now. You've been on the Supreme Court for 2 years. You were appointed there, right?
Right.
But so you've already been doing that. But if you get elected to do it, it would be for a 10-year term, and then you would be up for retention. But you were you were a trial court judge for 16 years, right?
I was.
And so you saw a lot of trials. You oversee your 150 jury trials, 300 bench trials.
Approximately, yes.
You know your way around the courtroom.
I'd like to think so.
You know your way about if there's an objection and you need somebody to rule, you're quick to do that?
Right.
Okay. You don't sit there and ponder what you can't, right?
You can't.
Okay.
No. That's the beauty of being on a reviewing court. You have time to contemplate the issues, whereas on the trial court, you're making the issues in real time.
So, and you were then appointed to the appellate court after you had been first an associate judge, then a full circuit court judge, circuit court of DuPage County, right?
Right.
Then appointed to the second district appellate court by the Illinois Supreme Court, right?
Right.
How does that happen? How do you get appointed to that?
Well, when there's a vacancy, then the Supreme Court appoints someone to that vacancy.
How do they know you?
I would imagine by reputation. I never applied for any of these jobs.
Uh-huh.
I received a call from my justice at the time, Justice Bob Thomas, and asked if I would be interested in sitting on the appellate court.
Okay, and he was on the Supreme Court at that time.
Correct.
People would know the name Bob Thomas because he was a kicker, field goal kicker for the Chicago Bears, right?
Correct.
Not just a kicker, one of the best.
One of the best.
One of the best.
Right.
And he, when you got that call, he was sitting on the Illinois Supreme Court.
Right.
He happened to be a Republican.
He is.
You're a Republican.
Correct.
You're running in this election as a Republican. Your opponent's a Democrat. You didn't have a contested primary, so you had to run, but wasn't contested, right?
Right.
But it's kind of a dual thing because when you get on the Supreme Court, if you do, well, you're on there now, okay? Keep coming back and forth. I'm used to thinking somebody's running, so I say, if you get there. But you are there.
I am.
Because you were appointed.
Right.
But if you get reelected, if you win election, that's the way to put it, I guess. And you won't be a partisan at that point, will you?
No.
You won't be a Republican justice. Somebody else will be a Democratic justice. You will all be one of the 7, if you're on there, and the other person, one of the 7 justices on the Illinois Supreme Court.
We run in partisan races in Illinois because that's the way the system is set up. And when I ran for the circuit court, I ran as a Republican. When I ran for the appellate court, I ran as a Republican. But on all those courts, when you become a judge, there's no red, there's no blue.
Now, the 2nd district is purple. The 3rd, where you sit now, the 3rd district where you're running is purple. That means it could go either way. And if the Republicans were to win both of those, which is conceivable since they're purple, well, then the majority shifts from 4-3 Democrat to 4-3 Republican, which would be the first time in modern times in 60 years that the Republicans had a majority.
That is true.
Big deal, as Joe Biden would say. He might say it a little bit more color to his language than I just did, right? Big deal, right?
Right.
Yeah. And so you're running in a big deal race. You're running in the 3rd district. You're running as the 2nd district judge, and people have to vote in your race. If they're watching this now, they have to reside in the 3rd district, right?
That is true.
Kankakee, DuPage, Grundy, Iroquois, LaSalle, Bureau, Will. Right?
Those are the counties, 7 counties.
If they're registered to vote in those counties, they can vote come November 8, right?
Correct.
They can choose you or your opponent, who's Democrat, Mary Kay O'Brien, right?
That is true.
2nd district, they have a choice between Elizabeth Rochford, the Democrat, and Mark Curran, the Republican, right?
Right.
2 big races.
2 big races.
Would you say, maybe not so much, because most of your you get about 120 cases a year that you collectively in the Supreme Court decide, right?
Approximately, right.
Most of those cases are not decided party line. The great majority of them are majority 6-1, 7-0, something like that, right?
It's a significant minority of cases that have anything to do with politics or decided on party lines, whether they have to do with politics or not.
So some people would, maybe I should have, and I don't know, and my peers would, they would start this race, they'd skip all of this stuff and just say, tell me, sir, how are you going to rule if abortion comes up, right?
Right.
How are you going to rule if you get a significant crime case? What do you think about capital punishment, okay? They would be doing that. They'd say, what do you think about no cash bail? They would say, what about pensions? Bam, bam, bam.
Right.
Jeff, why are you doing this? Because, why? Because people should have some perspective, really, right? You think?
Well, yeah. I mean, if I was running for legislative office, you would fire all those questions at me. But running for judicial office it's a different animal.
It is.
Yes.
Because as a justice, as one of 7 justices on the Illinois Supreme Court, you think your most important goal is to what?
To be fair, to provide justice to the people, to fairly resolve the cases for the litigants that appear before us. That's the case law side, and then the other side is to competently and efficiently administer the court system in the state of Illinois.
So how do we know? How do we know whether Justice Michael Burke is fair and will be fair if he's elected?
Well, I mean,
give me some guidance.
I have a 30-year track record to go on, and if you want to look up the bar ratings from the beginning of when I became an associate judge back in 1992, they've always been extremely high. In this race, we've been evaluated by the Illinois State Bar Association. I'm the only candidate in my race to receive a highly qualified, not a recommendation by the bar, but an evaluation by the bar. The attorneys who have rated me have found me, they rate in areas of impartiality, legal knowledge, court management, temperament, and I've always received high marks from the attorneys that appear before me. Also, every law enforcement group or association that has endorsed in this race up to this point has endorsed me, including the Illinois Fraternal Order of Police. I think the endorsements I have and the bar ratings that I've received and the rating from the Illinois State Bar Association can assure the voters that I am fair, I have been fair, and I will be fair.
What does it mean to be fair?
It means to decide the cases without bias, to look at the cases as they come, and each individual case on an individual basis, and decide that case based upon the facts and the law. Irrespective of how you might feel about the law, how you might feel about the facts, but you have to decide the case based upon the facts and the law. That's how you're fair. Each individual case.
But you have what Judge Posner calls priors, okay? He used that word from the criminal justice system, priors. I mean, and people know about you as a person.
Right.
Because you've been in public life, you've been a prosecutor, you've been a judge, you've had to run to get elected, first appointed in some instances, but then elected, and you're doing that now, right? And they know on the religion side you are a devout Catholic, right?
I am.
And what does that mean in terms of how you live your life?
Try and live my life according to my faith. Follow the dictates of the Ten Commandments, the Bible. Basically, try and live a moral, upstanding life according to the tenets of my faith.
What does that tell you about life?
What does that tell me about life?
Well, you hear this phrasing, life is precious. Catholics believe that. You believe that?
Well, I believe in the tenets of the Catholic faith. But I will also say that I'm not here to impose my faith upon other people through court decisions. You have to, you can't legislate from the bench. You can't impose your will, whether it's your religious beliefs, moral beliefs, or any other beliefs, on other people by ruling on cases. That's the legislature's job, is to set policy. The legislature's job. If I was running for legislative office, that question would be entirely appropriate. Running for judicial office, especially being the only person out of the 4 that you mentioned in the 2 races who is now sitting as a justice on the Illinois Supreme Court. You know, I have to be very circumspect about what I say in a public forum like this, as far as my personal beliefs, as they relate to issues that may appear before us on the court.
But yet, people want to know who you are.
Right.
More than just what stuff we've gone through, you know, what positions you've held, how many trials you've done, et cetera. They want to know who you are.
Well, they should know that I'm a moral person, that and I try and live according to my faith, but that I will not, nor have I ever, legislated from the bench. That's not our job. Nobody is electing me. Nobody has ever elected me when I've been elected to judicial office to be some uber legislator, to, again, impose policy, whether that's based upon my moral values or any other values that I have, and impose my policy on the citizens of the state as a judicial officer.
What's the state of the law? You can tell us that, I think, and they want to hear it from you. What's the state of the law about abortions in Illinois now?
Well, Illinois has in 2019, the governor signed the Illinois Reproductive Health Act, I believe it was titled. And that did away with a lot of the restrictions that were in place before as it relates to abortion. It also set forth in no uncertain terms that under the law, under that law, abortion is a fundamental right to a woman if she chooses to have one. There's also a part of that law that says that a healthcare provider, when confronted with a situation where there's a viable fetus, can perform an abortion when it's necessary to protect the health and life of the mother, of the patient. And that's been taken to mean mental health, emotional health as well as physical health. So at least that's the way it's been argued. And in that respect, people will often refer to Illinois as having abortion on demand for 9 months. I mean, that's the way,
I just get confused. If it's abortion on demand, how does the life and the health of the mother fit into the decision as to whether the doctor can give an abortion?
Well, again, according to that,
do an abortion.
According to that statute, it says that the doctor has to consider, with a viable fetus, the doctor has to consider the life and health.
With a viable fetus. What is a viable fetus under the law?
Well, that would be under science. That would not be under the law.
Under science.
Well, a fetus that could survive outside the womb.
And when is that usually in terms of?
I'm not a doctor. I have no idea.
You have no idea?
Well, I mean, maybe 20 weeks, 22 weeks. Again, I've never studied that. But all I'm saying is that's what the law says in the state of Illinois under the law that was signed by Governor Pritzker in 2019.
Yeah, I'm just totally confused. I thought that, and not because you say anything confusing, it's just because of the way it's usually said. Illinois, you can get an abortion anytime, any day, up to delivery. That's what you often hear because it's a fundamental right. But what you're saying is no. Well, after 20 weeks or so, then a doctor has to make a determination whether the life or the health of the mother is at issue, because if not, then they're not supposed to proceed with an abortion. Do I have that right? To the law.
That's the way I read that statute.
Okay.
That's the way I read the statute. It has not been interpreted. It hasn't been to court as far as I'm aware. As far as what does it mean to protect the health, or not necessarily protect the life of the mother, certainly that's fairly easy to define. But what does it mean to protect the health of the mother? And again, if the argument is that this provider believes that it's important to protect the emotional or mental health of the mother, then it would, I would imagine, come under that statute. But again, that hasn't been litigated that I'm aware of.
Okay, it could be litigated.
It could, and in that regard, then we would have to decide it.
But it hasn't been, and so how is the situation in Illinois any different, if at all, now that Roe v. Wade has been overturned by the Dobbs decision?
Well, it's not.
It's not.
It's not.
It's not affected at all.
No. Okay. The thing, many of the people who are hearing about Roe being overturned by Dobbs were under the mistaken impression that then abortion would be illegal throughout the United States. What Dobbs did was very specifically sent the issue of abortion back to the state legislatures. And Illinois has spoken on that. Now, we see throughout the country there are state legislatures that are taking action. And actually, the governor in the paper has indicated he may call the legislature back into session to take action regarding this. But he's looking to, further strengthen abortion rights, where some of the other states are limiting abortion rights. But again, it depends on the several states. They get to decide. The elected officials in those states, in those legislatures, get to decide for themselves.
So what, in a nutshell, did the Dobbs decision do, the U.S. Supreme Court?
Well, basically, it said that the constitutional underpinning of Roe v. Wade and later Casey versus Planned Parenthood was faulty. The dissent argued basically stare decisis, meaning we should follow the decision because that's been the decision for the last 50 years. Abortion has been a U.S. constitutional right since I've been in high school. And that's what the dissent was saying. The majority was looking at this concept of substantive due process under the 14th Amendment. Because the 14th Amendment allows or keeps the states from depriving its citizens of life, liberty, or property without due process of law. There's, of course, procedural due process, and we're not talking about that here. There's this concept that has developed over time of substantive due process. What is a constitutionally protected liberty interest that's not enumerated in the Constitution? And, it's ever since the late 19th century, the idea of substantive due process has been in and out of vogue in different forms. It really came back into the fore in the case of Griswold versus Connecticut in 1963, or it was 65, but it was around that time where the Warren Court basically brought that back into play, saying that in that case involved a married couple's right to obtain contraceptives. And the court said that that was a liberty interest protected by the 14th Amendment. So now what Dobbs said is that that abortion is not a liberty interest protected by the Constitution. Because what it looked to was the analysis that's taken place over time. And, the Supreme Court has said that in order to be protected, it has to be a right that's deeply rooted in the history and traditions of the country in order to come under this nebulous concept of liberty under the 14th Amendment. And the Dobbs court went through an analysis of the law at the time the 14th Amendment was ratified, which is in 1868, and almost every state that was in existence at the time banned abortion, and the territories that later became states banned abortion. So they said this is not a right that's firmly rooted in the history and tradition of the United States. In fact, the opposite is true. There was no right because abortion was illegal throughout the land in most states and in almost every circumstance.
So the majority on the court, and this was a split decision on some things. It was 5-4, some 6-3, something like that.
Right.
Because there were concurring opinions, but certainly the majority, whether it's 5-4 or 6-3, those folks, those justices who basically decided, as you've just stated, they're what people often call originalists, textualists. Would that be correct?
That's correct. It actually would have been 5-4 on the way I described it.
Okay.
Because Justice Roberts wrote a separate opinion. It didn't really go along with that analysis.
He would have decided without overturning Roe, but basically saying the Mississippi statute before them was constitutional.
Right.
But he wouldn't have gone further.
Under Casey.
Yeah. Okay.
Right.
But there was 5-4 who really, it seems, did what you said. They were originalists. They went through that history. They went through what the wording said. This is what these prior decisions had decided. This is our precedent, not Roe. And you're an originalist, right?
Well, I am. I mean, I that's the way I view the Constitution. That's the way I view statutes. I mean, I would say, I'm more of a textualist. I like to look at the text of these, and if they're clear and unambiguous, they should be applied as written, whether it's a constitutional provision from the United States Constitution, the Illinois Constitution, or a statute that I may be interpreting from the Illinois General Assembly. If the General Assembly passes a law, it's clear and unambiguous, it should be applied as written. Whether I would have voted for it or whether I would have signed it as a governor, doesn't matter. It should be applied as written. And I say that to people when I'm out talking to groups. I say, if you don't like the laws that are passed by the legislature, your obligation is to get new legislators, not to go to the courts.
Right. Excuse me. So you don't legislate. Is that what you say?
That's what I'm saying.
Yes.
Right.
You do what as a judge? If you don't legislate, what do you do?
We apply the law as it's written to the facts. We're called upon to interpret the law and interpret constitutional provisions from time to time when interpreting them in light of a certain set of facts is maybe more of a gray area. And then sometimes many statutes, as you can imagine, written by the General Assembly are not the clearest as it applies to a certain situation. So then we have to interpret that and try and glean the legislative intent from those statutes.
Okay. If you had a case before you dealing with abortion issues, would you start with the U.S. Constitution? Would you start with the Illinois Constitution? Where would you start as you began to think about that?
Well, you'd probably start with the statute, and then look at the statute, and then again, a lot of it is determined by the path that you're led down by the lawyers to some degree. You have to listen to their arguments and read their briefs and the cases that they're citing. So really, if you look at the issue of abortion, again, because it's not an enumerated right in any constitution, whether the U.S. or the state constitution. It's not an enumerated right. Mm-hmm. So I don't know, where you would go other than to say that, again, Dobbs has now sent it back to the legislatures, and then we have to look at the legislature's enactment to determine whether it's, otherwise valid. But remember, the U.S. Supreme Court didn't say abortion was illegal. It sent it back for regulation by the states. So, that's kind of a tricky question as to where do you start, what constitution, because really Dobbs is the ultimate arbiter of what the 14th Amendment says. And they said, this is a state issue. Let the state legislatures decide it.
So you start certainly with you certainly take a look at the Illinois statute, if that's right, being litigated then, which talks about, you referred to it, I guess, as being signed in, 2020? The Illinois statute that made abortion a fundamental
2019.
Right? 2019, okay.
Right.
You're certainly going to look at that because that's the law in Illinois.
Sure.
You might want to look at the U.S. Constitution and remind yourself what the 14th Amendment says.
Right.
You might want to look at the Dobbs decision because that's your guide, right?
Right.
They said a few things other than just sending it back. They gave you the history that you talked about, right?
Correct.
So those are the things you'd be. Anything else that I've?
No. But again, it's put it back in the legislature's lap, not necessarily in the courts. Now, would we be called upon to review legislation at some point in time? Possibly.
So you come back, and you come back next week and every week to Public Affairs.